Business Law School, and it's really my pleasure to welcome you, or in some cases to re-welcome you to this ESQ, this 5th annual ESQ conference. It's my role now, and I'm enormously pleased to do so, to welcome Gary Lynch as our keynote speaker. Gary's exceptional career exemplifies the broad range of practice areas and opportunities being explored in this conference today. His career has included public service as a government regulator, private legal practice in a major law firm, and experience as an in-house legal counsel at 2 of the country's most outstanding private equity firms. He's a 1975 graduate of this law school, a life member of the law school's Board of Visitors, and the distinguished alumnus after whom the Lynch Commons, where many of you hang out downstairs on the first floor of the Law Review wing, was named. Currently, Gary Lynch is the Chief Legal Officer and Executive Vice President of Morgan Stanley. Prior to joining Morgan Stanley, he was Executive Vice Chairman of Credit Suisse First Boston, which he joined as Global General Counsel in 2001. The next year, he was named Vice Chairman and placed in charge of overseeing both the research and legal and compliance divisions. And in July 2004, he was named Executive Vice Chairman of the Credit Suisse First Boston. Prior to that, he served as Director of the Enforcement Division of the Securities and Exchange Commission. At 34, one of the youngest people ever to hold this position. He is credited with bringing about a string of securities prosecutions that is unequaled in the agency's history. The New York Times reported that in 1994, Mr. Lynch helped convict a who's who of Wall Street's most famous miscreants, such as Ivan Boesky, Michael Milliken, and Drexel Burnham Lambert. In 1986, Esquire magazine picked him as one of the 72 men and women under 40 who were changing America for the better, and he's earned a number of other distinguished service awards. Following his service at the SEC, Gary joined the Davis Polk law firm, where he advised and represented a wide cross-section of that firm's clients, including major public companies and investment and accounting firms. As a white-collar defense counsel, again, he found his way on many top lawyer or most influential lawyer lists, often the first attorney called when companies were accused of wrongdoing. He was known for keeping his clients out of the headlines and for some of the biggest defense verdicts on record. While a hugely successful defense counsel during his law firm period, he was also in high demand to oversee internal investigations on behalf of senior management. About him, it has been said, he has an expertise and knowledge of the business he investigates so that people have confidence when he puts his imprimatur on an investigation that it will be first-rate and exhaustive, and that he would not tolerate anything that is a whitewash or less than a thorough effort. His appointment in July 2005 as Chief Legal Officer of Morgan Stanley was widely noticed and heralded. The Wall Street Journal called him a legal heavyweight. In announcing the appointment, John Mack, the CEO of Morgan Stanley and another Duke grad, talked about Gary's credibility, his strategic insight, and his great ability to give judgment with both a legal and a businessman's perspective. He has integrity, he's trusted, and when he speaks, people believe him. I invite you to hear his remarks and welcome Gary Lynch with me.
Thank you. That was a great introduction. Probably longer than my remarks, though. Well, thanks for the opportunity to come back to Duke and attend the symposium and share some of my career experiences. In thinking back on the development of my career in preparation for being here, I realized how little of what I did was planned, however. It's become sort of an accidental career, and I thought, actually, before being on the 2 panels this morning, maybe I was somewhat unique in that. I think if there's a theme that emerges from today, is how many careers are accidental, how difficult it is to plan a 30 or 35-year career, and how important it is to find a job that's interesting, that intrigues you, and stick with it, and then take opportunities as they present themselves. I guess from the days when I was at the SEC, where I had to caveat everything I was saying by saying I'm speaking for myself and not for the commission, I always give caveats when I speak. And I'll be the first to say that what I'm going to say to you today is just based on my experience, and that's one experience. And so to the extent that there are a number of other practitioners here who might disagree with the views that I formed based on those experiences, but so be it. I also want to apologize for talking about myself. But as I've been thinking about how do you do a presentation like this, I couldn't really think of any other way of approaching it. So what I'm going to try to do is speak for maybe 20 minutes or so. I understand we have a drop dead time of 12:50 and then open it up to questions, although if I say something where you can't help yourself and you want to ask a question in the middle of the presentation, feel free to do so. The trick here, I think, is going to be to do it in 20 minutes or so. I think when lawyers start talking about their careers, they tend to wax on for a while. So I'll try to be brief, but if it looks, I'll keep an eye on the clock, and I may have to truncate it depending on how we're doing. I think it's fair to say that when I came here to Duke, I guess it was 1972, I had no idea what lawyers did. It sounded like a good idea to go to law school, and a number of people had said to me, go to law school if you don't know what to do, because there are any number of things that you can do coming out of that. And I took that to heart and really followed it up to my third year of law school. I was one of the few people at that time who, come the third year recruiting season, didn't interview at all, because I was so uncertain about what I wanted to do. I wasn't even certain what part of the country I wanted to live in. And I had this sense that somehow it was unethical to interview with law firms and have them fly me around the country and feed me and everything if I really wasn't serious about working for that law firm in that city. That just shows how naive I was at the time. Give me that opportunity now, I'm off to LA, I'm off to San Francisco, I'm off to Boston. But back then, somehow it seemed it was a matter of principle with me. So I went through the recruiting season, and come the spring, I started looking around because I realized graduation was coming up and I needed to find a way to pay my expenses. So I had, at that time, reached a couple of clear decisions in my career. I knew that I never wanted to work for a very large law firm. Of course, 15 years later, I became a partner of Davis Polk. And I also knew that I never wanted to work for a large company. And now I'm the CLO of a company with 53,000 employees. So that just goes to show how you may not know exactly what you want to do as you're coming out of law school. Excuse me for a second. So I made a decision to go to Washington, D.C., because it was about halfway back from the part of the country that I grew up in. I grew up in upstate New York. And to work for a small law firm. I think at that time there were 18 lawyers in the firm that I joined. And I remember George Christie, and I guess George Christie is still teaching here. George Christie gave me some advice one time. I love George Christie, by the way. George said, that one of the things that he found is that it was very difficult to leave a job unless you were truly miserable. That if you were in a job and things were going along okay, you tended to stay there. And he was talking to me about his decision to leave a Washington law firm and to become a professor. Well, I guess the good thing is, for me as my career developed, is I took a job wherein I was truly miserable. Truly miserable. What I always thought, well, I wanted to work for a small firm because it would feel collegial. And what I hadn't focused on is if you're in a small firm and you don't like the lawyer that you're working with, the partner that you're working with, or the type of work that you're doing, there's no place to go. Like you can't transfer over and work for one of the 100 other partners in the firm. You're sort of stuck. So long and short of it is, about a year into that experience, I made a decision to leave the firm. And again, in my accidental career, I was walking down Georgetown, the streets of Georgetown in Washington one day, and ran into a lawyer who worked at the law firm that I had clerked for between my second and third year. And she had relocated to Washington and was working for the SEC. And she told me what a great place it was and how interesting the work was. And I interviewed like a week later, and 2 weeks later, I had a new job. So to me, I look back on my accidental career, and it was fortuitous that I was at a job that I really was to the point of where it wasn't that I just mildly disliked it. I just couldn't get myself in that door every morning. So I went to the SEC, and as it turned out for me, it was just a wonderful opportunity. one of the, looking back on it, the thing that appealed to me was just the independence of the job. I'd gone from, again, a small law firm where I had a partner looking over everything that I had done. And again, for better or worse, and sometimes it's for worse in a government agency, the training isn't what it should be. But the good thing is they just give you a case and you get to run with it. So within about 2 weeks of joining the SEC, I was out in Los Angeles taking depositions. And, long story short, I spent 13 years at the commission, thinking when I joined the SEC that I was going to be there for maybe 2.5 years. And it turned into a career which actually prepared me for everything that came after for me. I'm sorry, I'm having trouble with water. And can you hear me without this? And there were good times and there were bad times at the SEC. At age 34, as Kate mentioned, I was named director of enforcement. I had 700 people reporting to me, which was a huge responsibility. But again, the nature of the work was always, to me, very interesting. The bad side of it was at that time involved in controversial matters, as it is today, frankly. I think some things never change. And I think I spent, at least 35 times testifying before congressional committees from the time that I was 34 years old to 39, which, again, bad and good. The good thing was it gave me an experience at an early age that served me well as I've gone after that. And the other thing about the SEC is it gave me management experience, which, to be candid, is not something that you generally acquire at most law firms. Having spent 13 years at the SEC, in 1989, I woke up one morning, and it literally just came like that. I recognized that things were going very well for me. I was the director of enforcement. I had been director for 5 years. Generally well received. Again, a few congressional blips, but pretty well thought of. And it occurred to me, this is not going to go on for that long, because the way things work in government, at least at that level, at least in that kind of position, was that eventually something was going to come up, or I was going to rub someone the wrong way, or there'd be a new chairman who decided that they wanted their own person in the job. So again, I think, to me, this is another important thing that I learned, is control your own timing. And I had this enormous sense of obligation to the agency and the mission of the agency, investor protection. And I had been traveling around the world negotiating agreements with different governments. This was back in the infancy of the globalization of the securities market. So as director of enforcement, I had the idea, along with others, that we needed information sharing arrangements in place with foreign governments. So having been on the road for about a week and a half and calling back in at the end of the day, I realized that things were running perfectly well without me. In fact, in some ways, maybe better without me. And by stepping down, I give the opportunity for others in the organization to move up. And I guess most importantly for me, I was controlling the timing. So I'll never forget the day I went in to see the chairman of the SEC at the time, just to discuss with him my eventual departure from the agency. And that was about 9:30 in the morning. He had decided that he really couldn't live with the elite coming out of the agency that I was leaving. So this is something I was ruminating about and pretty much had come to a decision. But an hour and 15 minutes later, the agency actually issued a press release that I was leaving. So much for any notion of reconsideration. The good thing about that was that it became sort of my advertisement, that I'm leaving and I'm looking for a new job. So again, great years at the government. I think back on, again, the reason I was there was because I had made a decision, not really understanding what I wanted to do as a lawyer coming out of law school. It was so bad that I ended up at the SEC, but I must say I loved every one of my days of the 13 years at the commission, with minor exceptions. So then I entered the next phase of my career, which was a partner in a major law firm. And there I went from basically managing people, 700 people at the SEC, to managing cases that I had. And I made this point before, but I'll make it again, and I'm sure there'll be some lawyers in law firms that may dispute this, but basically, there's very little people management at a law firm. Certainly, there are training programs, there's an effort to manage careers, but in terms of day-to-day hierarchies where there's people management, there's really not that much of it. So I went from a time where a large part of what I did, probably 50% of the way I spent my time, was managing the people under my supervision, to managing cases. And I think, again, another major distinction between the government and a law firm is that I went from case to case, from client to client. So suddenly I'd gone from a situation where basically I had one client, and that was the commission of the SEC. I had to please them. To please them, I had to please the public, I had to please Congress, but really in terms of, I had one client, and so I didn't have to manage a lot of competing considerations. At a law firm, I managed cases, but I also had a number of clients to manage at the same time. It required a very different skill set. Now, I will say, I got an opportunity to work with just very, very talented lawyers at every level. And that was one of the things, frankly, I didn't have at the commission, because the way things had evolved at the commission, I found myself, I think, at age 31 as an associate director with about 300 people reporting to me. So it wasn't as though there was a lot of mentoring that brought me there. So it was largely based on a small private practice experience and then some experience under others at the SEC. I was suddenly in a leadership position. And with not that many people to bounce things off of. The great thing about Davis Polk was that I had partners with a wide range of experience that I could rely on, and I also had associates who were top-notch associates who worked hard and supported me in what I was doing. I have to say, when I think about the law firm experience, it's very easy for me to think back and talk about being a partner in a law firm. I really can't speak to what it's like to be an associate in a law firm, and for that I thank God. But sorry, folks out there who are partners in law firms. But long and short of it was, again, I got 12 years into my experience at Davis Polk, where I was very happy, just as I was happy at the SEC. And an opportunity presented itself. One of my major clients was Morgan Stanley. For those of you who read the Wall Street Journal, you're probably familiar with this tale, but there was a lot of turmoil. The president of Morgan Stanley, John Mack, left the firm. 3 months later, he resurfaces as the CEO of Credit Suisse First Boston. I remember reading the article in the Wall Street Journal that he was going there. I thought, oh, that's very interesting. And a couple weeks later, got a call, and so I entered into what was my third career. And again, a very different career, a very different thing than I had done at a law firm, but in some ways, very much like my government experience. And I say that, people say, well, how can being a general counsel of an investment bank be like a governmental experience? Because it's kind of the other side of the table. And the reason for that is it's back to people management. I had a large organization that reported to me in the legal and compliance area. As Kate mentioned, about a year and a half into that, again, for those of you who read the papers, there was a lot of controversy over research and the relationship between research provided by investment banking firms and their solicitation of investment banking business. So my CEO had the idea that if it was a control area and an area where we need to focus on, why not have research report to me as well as legal and compliance? So I truly had a split between what was really just purely a business function and the legal and compliance function, and then eventually went on the executive board of the parent at Credit Suisse. And then, again, through an improbable series of events, the person who had hired me to come to Credit Suisse, having left Credit Suisse, was rehired back at Morgan Stanley as the chairman and CEO of Morgan Stanley. So a year and a half later, I moved to Morgan Stanley again, which had been one of my big clients, but a client that I always valued working for. And there, again, my experience is very much like it was at Credit Suisse. It's a mixed experience of lawyering, although as the years go on, I think it's pretty clear that I do very little pure lawyering. I mentioned on one of the panels that I was on earlier today that I can't remember the last time I actually looked at a statute. And I did read a case about 3 months ago. I think it was the first time I read a case in about 5 years. So much more of what I do is working with our business people, whether they're bankers, traders, or otherwise, and offering my judgment on transactions. And frankly, by the time that matters come to me, usually, with some exceptions, but usually we've dotted the I's and crossed the T's under the applicable law of whatever country we're doing business in. And then it comes down to a question of judgment. Is this the type of business that we want to do or not do? And within the investment banking firms, this has actually been elevated into a function. It's not merely just part of what a lawyer does. At my current firm, we call it franchise risk. At my previous firm, we call it the Reputational Risk Review Committee. But there's actually a formal function that I headed up at Credit Suisse, now I head up at Morgan Stanley, again, which only kicks in when there are transactions, trades, or individuals that we're going to deal with that raise reputational risk type of issues. And then we have a group of people who sit around, consider that, and decide whether or not we should go forward with it. So again, basically three careers, obviously all related, but all very much focused on the securities markets from different perspectives. I guess the notes for this said I would talk a little bit about the business and legal issues that are currently of interest to me or that we focus on. And obviously, there's only so much of that I can do. But one of the issues I thought I'd just briefly address, because I've seen a lot written about it, most of which has been skewed from one side or another, is what's happening to the U.S. capital markets because of, well, depending on which article you read, Sarbanes-Oxley or private litigation or whatever. And again, depending on what side of the issue you take here, either our markets are disappearing, and they're disappearing because of Sarbanes-Oxley and other related matters, or the other side of it is the big bad investment banks just want to make more money, and that's why they're complaining about this very legitimate regulation of Sarbanes-Oxley. And I guess the first thing I'd say in response to all that is we're a global business, and at the end of the day, if it wasn't for the fact that I'm an American and a United States citizen, we really don't care where we do business. I mean, we're just as happy to do a deal in Hong Kong or London or Frankfurt as we are to do in the United States. So there's really no financial motivation behind this. But I think one of the things that I've seen now, 25 years plus in the business, is there was a time, in fact, until relatively recently, where the U.S. markets were the preeminent markets of the world, where you really couldn't get a major deal done unless you had a registered U.S. tranche of the deal. That's no longer true today. And that's one of the reasons why we see the business flowing to London and flowing to Hong Kong. And we did a transaction for the China Construction Bank, their IPO, which was an $8 billion deal in Hong Kong. We had subscriptions for that deal for $80 billion. So if you're a company sitting in China or India or in Scandinavia, and you're trying to decide where you're going to go to do your IPO, and you can go to a market where you can tap that kind of capital as you can now without encountering Sarbanes-Oxley, without encountering the private litigation, securities litigation, then why would you ever do that? I guess the other thing I'd point to is a seminal event, at least in my experience, was back at my former employer, Credit Suisse. We worked on the IPO of China Life, which was a large insurance company. And they did the IPO, and about 3 weeks after the IPO, there was a press story that surfaced with regard to a relatively minor issue within the insurance company. And the stock, which had come out, and I'm just making up numbers now, but I think like in the 17 range and it traded up to 26, went down to 23. And they were immediately hit with a lawsuit for this issue, which again, at the end of the day, was a de minimis issue for the firm. But that was basically the last, or at least one of the last major IPOs coming out of Asia at that point, once that lawsuit was filed on that particular issue. So what am I rambling on about other than complaining about government, which is what all government people do when they leave government, right? You talk about the golden years and how great it was when you were there and how reasonable you were. It's just, this is a simple fact. That is the way it works. What I'm saying is basically we have lost the position as the preeminent market in the world. And it's not so much that the investment banks are focused on that because we want to make more money. We're focused on it because certainly if you live and work in New York, it's a huge part of the economy and a huge part of the tax base. So I leave it to Jim Cox and others to talk about what the real possibility is for reform in Sarbanes-Oxley, where I predict maybe on the fringes they might do something small. What the real possibility is for reform in private securities litigation, where I'm quite confident nothing's going to happen. And you look out, and I think it's just a new world that we need to adjust to. That it's a world where the U.S. markets are one of 3 important markets, maybe one of 4 important markets around the world, and no longer the preeminent markets. The other point I'd make is just how global the world has become. I came across a speech that I gave, I guess over like 20 years ago in London, talking about globalization and how and then I was a regulator, and I talked about the need for regulators to cooperate because otherwise it was going to be impossible to really police the markets, because so much happened in one market that affected another, and unless there was complete exchange of information and cooperation, we were all going to quickly become ineffective. I think back because at the time I was talking about globalization and how important it was, and talked about it as though it was honest. And in fact, 20 years later, it's finally honest, but basically it took that long to get there. And so it's such an important part of what I do now in the role I'm in, to focus on regulation law around the world. I mean, just to give you an example of a recent trip I took, we flew from New York, Beijing, Shanghai, Hong Kong, Dubai, London, and then back. And as we were going, we were flying to offices, which obviously Morgan Stanley already has. But I was thinking as we were flying, particularly the Hong Kong to Dubai route, that we were flying over territory probably within 3 years where we'll have offices there as well. And again, it just shows the importance of globalization and the importance of having lawyers from diverse backgrounds who can live and who want to live and work in those markets. And then just finally, just one story. I was here 2 weeks ago recruiting over on the main campus for undergrads for our summer program. And I was surprised, and we were recruiting, this is for juniors to come in, basically work for the summer, then eventually maybe become trainees and work for Morgan Stanley for 2 years, and then decide after that where they want to go. And I'd say I was approached by at least 8 students, either Chinese American, who were asking if there was any possibility that they could come into the training program and then move back to China. And I said, yeah, I think there's that possibility. Because obviously that's exactly what we're trying to do, to build a very diverse workforce here in the United States if we can, and then move them around the world so we can do business on the ground with people who are local, who really understand the culture, and who can work in that environment. So, as I promised, I sort of rambled on for 20 minutes or so. We have 10 minutes to go, and with that, I'll see if there are any questions. Yes?
If you were hoping to, if you're in law school right now and you're hoping to get involved in these emerging capital markets like London, Hong Kong, and Dubai, would you recommend going like an LLM route or joining a global law firm, and work will come to you anyway, and you'll get the training you need?
Well, it depends on what you want to be. If you want to be a lawyer, then I would say, not the LLM is. I would argue is largely irrelevant. If you want to have the option of being a banker someday or a trader. I think it's marginally helpful to have the LLM, although, I don't know what the percentage is, but we have a very high percentage of our investment bankers who have a JD and only a JD. And generally the career route for them is to have been at a law firm, be a deal lawyer, generally an M&A lawyer, and then move over to be bankers. But I don't know if it's 15% or 20%, but my guess is somewhere in that range of our MDs who are bankers have a JD and not an LLM. So certainly, if you want to be a lawyer at an investment bank, no need for the LLM. If you want to have more options open to you and maybe move over to be a banker, marginally helpful to have that LLM as well. But there's still the opportunity. Obviously, a lot of people have pursued it to move from, I guess, from a law firm, generally, from a law firm as an M&A lawyer to become a banker. Any other questions? John Hardiman.
Mr. Lynch. And let me just announce to everybody that I play golf with Lynch, and he won't be given a speech for 20 minutes on his golf career anytime soon. For the students who may be considering a career in the public sector, whether it's the SEC or something else, do you have a view as to whether or not they're better off going directly to whatever the agency might be, as opposed to going to a firm for a couple of years and hopefully having a better experience than you did at your first firm?
John always throws me softballs like that. So, I have a very strong view on that, actually, and that is, while I was only at a law firm for a short period of time, the training that I got there, or I should say the abuse that I got there, was very helpful for me in the rest of my career because it gave me some idea of what it was like to be a practicing lawyer. I saw other lawyers who had come out of law school and went directly into government, and quite frankly, I mean, maybe there are governmental agencies now, I hate to say it, almost 30 years later, who have good training programs, but at least back then, the SEC had none, and so. Based on my year with a law firm, and frankly, the clinical classes that I took here, I felt like I was better positioned to actually practice at the agency, little things like writing memos to files of conversations, which I did as a matter of routine, was taught to do at the law firm, which frankly, all my colleagues at the SEC weren't doing. I mean, for those who are just coming right out of law school, how would they know? That's sort of a good thing to do to make a record of what someone is saying to you. So I had then, I guess, and unless you're going somewhere now where coming right out of law school, you think there's a great training program, that a private, being in private practice at a law firm where you receive training is a great idea before you embark upon a government career. Having said that, I think government service is a great thing to do early on in one's career, and if you don't have the opportunity to do that, later on in one's career. I mean, I've other than my first experience at a law firm, I've loved all my jobs, and that's the absolute truth. But the SEC's, I feel like looking back on it, the SEC gave me an opportunity at a much earlier age than I would have had at a law firm or at a company, obviously to have real responsibility and feel real accountability for what I was doing. So it's, again, not everyone has the experience that I have, but I think government service is a great thing to do at any point in one's career. But if all things being equal, if you could work somewhere else for several years before going into government, I think I'd recommend that as a course. Any other questions? Yes?
What do you think about how banks are managing kind of conflicts they might have between their obligations as agents and then also as a principal investor?
I think as a legal matter, we do a reasonably good job of managing the conflicts. And most of the conflicts arise, there was the research issue a couple of years ago where the conflict was between retail customers and investment banking clients. And I think it's fair to say, looking back on it, the banks didn't do a good enough job managing that conflict. But more conflicts arise between clients or between our very sophisticated clients and banks themselves. And there I think we do a pretty good job of managing it in the sense as a legal matter and pointing out what the conflicts are, identifying them so that sophisticated counterparties understand what our conflicts are as we enter into transactions. Managing the business conflicts that come out of it is another kettle of fish, and I think very difficult to do. I mean, one of the controversies right now is that you see more and more firms getting into principal activities, whether it's, well, private equity is a good example. I guess it was, I didn't see a Wall Street Journal today, but I guess it was announced that Goldman Sachs is raising a $19 billion private equity fund. And obviously, to the extent they do that, and they're also an investment banker to private equity funds like KKR and any number of other major private equity funds, there'll be times when they're competing on deals with those clients, which again, in another setting, they hope to represent in other private equity deals as their investment bankers. So all that's by way of saying, I think there are some business conflicts that are inevitable as more and more investment banks get into principal activities, and we have clients in those same principal activities, and eventually at some point they're going to say enough is enough, guys. You want to be our advisor, but don't be our competitor. But in terms of legal issues, I think we do a good job of doing that. Most banks, ourselves included, have set up an infrastructure for dealing with conflicts, but that is a relatively recent matter. I mean, that's been over the last 3 or 4 years, and driven in part by the research settlement and the fact that probably all of the banks let things get a little out of control in that area without really focusing as much as they should have on the conflicts that were inherent in that business. Yes?
You mentioned controlling your own timing. Can you expound on that concept a little bit?
Well, it's actually related to what I was saying before about you really have to hate a job generally before you actually leave it. And making the point that I was fortunate enough to really hate the job so I could leave it. A lot of people are in jobs, lawyers included, where they make a reasonable amount of money. It's okay. I mean, it's not really something that is their dream job, but it's okay, and they stay on and do that. They don't find it necessarily very interesting work or intriguing work, but they stay on and doing it. I think it's very difficult to be successful if that's how you view your day-to-day activity. Unless you really find it intriguing and interesting and feel like you're working with people that you like and who are part of an organization that you want to be part of, you're not going to be successful. So to the extent that you're in a job and you're just in the job, at some point or another, if you're not successful, and I don't think you're going to be if you don't find it interesting, eventually someone's going to say, shouldn't you be doing something different? And encourage you to leave. And then at that point, you're out there looking for a job, looking for a new opportunity in a setting where you're not, just sitting back and saying, I'm happy, I'm going to control the timing, I'm going to control my own destiny. And I guess the point I was simply making is you're much better off controlling your own destiny. You're much better off being in a position where you say, this has been great, but there's this opportunity out there and I'm intrigued by it, and I think maybe I'll do that for a while, as opposed to someone coming to you and saying, you need to find something else to do. It's really not working out here for you. And with that,
I got the last question.
Yeah.
You haven't looked at you looked at a case once in the last 5 years, so maybe you haven't worked that closely with law firms. But what what makes a good law firm or a good lawyer that you hire? How do you decide to go back to people? What can our students, as they become associates or in the private practice, try to do to make a positive impression?
I work with a lot of law firms, but I expect them to read the cases and tell me what the case means, so I don't have to read the case. We spend, all kidding aside, we spend about $500 million a year in outside law firms. I mean, it's I mentioned that number to other general counsel, and they can't believe it. And it's just because of the nature of the business that we're in, we retain a lot of law firms all over the world. I think last year we had something like 862 law firms that we had worked with to one extent or another. And at the end of the day, it comes down to service. I mean, is this a law firm that's really interested in doing our business? Do they give us quick turnaround? Are they loyal? I mean, there have been occasions, both at Credit Suisse and at Morgan Stanley, where we've used law firms that have associations with other banks, where at the end of the day, I really wonder if they're looking out for Morgan Stanley's best interest or Credit Suisse when I was there. or if they're trying to like walk a line so as not to offend either a major company in the country where they're doing business or another client in that country. And I will say, I think there is a difference, without mentioning names, I do think there is a difference in the quality of work product that you get. I'm a big believer in retaining specialists. I think that comes from my private practice experience where I did a lot of work with the SEC and occasionally would compete against someone who would, this would be the third enforcement investigation they'd handled in the last decade, and I would do it on a daily basis. So they would have, an associate produce a memo on insider trading and what it means to be liable as a tippee and cost the client $75,000 for that work product. I didn't need that work product. I understood what it meant for tippee liability. So big believer in specialists, and I'm a big believer in good service.
Thank you very much for coming.
Thank you.